Pamela, I've heard this discussion before, and I admit that I don't know if I have an answer for it. Unlike alcohol, and let's be clear with this, if you consume alcohol within a certain amount of time, and let's say you operate a motor vehicle and you're pulled over by police, you're given a sobriety test or whatever, they can determine pretty clearly how much alcohol you had over the period of time. The science is at that point. But when it comes to marijuana, science most certainly is not at that point. As a matter of fact, you could potentially, if you were pulled over by a police officer and you had a medical marijuana card, you could test positive for marijuana, but not technically be under the influence. You would not be impaired, as in you couldn't drive, because, as I understand it, it stays in your system for a long time, right?
Yeah, and joining us to explain this a little bit more, because we have medical marijuana here in Arizona, so you have people with cards who have legitimately been told that, hey, you know, you're allowed to have this in your system, is John Balitis. He is an attorney and director at Fennemore Craig Law Firm here in Phoenix. Thanks for joining us, sir.
Thank you, Pamela.
Well, to talk to us a little bit about this, talk to us about one of the questions that's been surrounding this case where can you prosecute drivers simply for having a trace of marijuana in their system?
Well, according to the decision that the Court of Appeals issued yesterday in Arizona, the answer to that question is yes. And to put it in context, what we all have to understand, you know, whether we're talking about medical marijuana or not, is that in Arizona, it's unlawful to be operating a vehicle, not just if you're impaired, but also if you have a trace of a controlled substance in your system.
Wow.
Okay.
So, you know, there are two prongs under the DUI law here in Arizona, and they both are available to law enforcement to prosecute and convict drivers. And of course, the question, the issue that arises then with medical marijuana is, if you are a medical marijuana card holder and you are pulled over and you're not impaired, but you have used the drug legally within a period of time that it still remains or its metabolites remain in your body, can then, under this version or this provision in the DUI law, can you be prosecuted and convicted? And the answer, according to the court, is yes, despite the fact that you have the card and despite the fact that you're using the drug for a medicinal purpose.
Well, this is hardly the first time we've run into laws necessarily that are in conflict with one another, because it strikes me that when the laws were originally written, they probably didn't have medical marijuana in mind. They certainly didn't have the idea that a substance could stay in your system and not impair you necessarily. So is this just a matter of we need to have the laws changed? And as someone who believes that marijuana should be legal, by the way, I'm on that side of the fence, not just medicinal, all of it. What is the middle ground? Because I still don't think people that are literally high should be driving, but how do you tell?
Well, there's a couple of questions there. Let me deal with. I'll answer the first one. You know, the answer to the first question about whether or not the laws have, you know, kept up with the times, the answer really is yes and no. The DUI statute, which has been on the books for quite a while, and the court points this out in the decision yesterday, does not require law enforcement to prove, or the state to prove in a case, that the individual who's pulled over and arrested consumed the drug illegally. It's silent on the issue. So if you're using, you know, medical marijuana, the statute doesn't draw a distinction between marijuana and medical marijuana. It just says that if you have THC or its metabolite in your system, you can be prosecuted and convicted when you're driving a car. Now, the next question, though, really, the other side of that coin, I should say, is the medical marijuana statute itself. Why wasn't an exception for this situation carved out in the referendum before the voters passed it? And really, it begs the question, was it an oversight or was it intentional? You know, we have a lot of concern and heightened scrutiny about DUI issues nowadays. And it's possible, if you went to the drafters of the referendum, they may say, we didn't want to go there. We didn't want to be carving out an exception for somebody taking that drug and operating a vehicle. Now, in terms of whether or not you could create a baseline standard for marijuana like we have for alcohol, that law enforcement
BAC, like we hear about, right?
Absolutely. Some states have done that. Pennsylvania, for example, is one jurisdiction that has developed a marijuana content threshold where law enforcement can judge whether or not a person is impaired, not by subjective observation, but by the amount of THC nanograms per milliliter in the person's blood. But it's much more subjective and much trickier than it is with alcohol because of how marijuana and its metabolites are processed by the body and stored in the body. That's why I think we don't have a lot of states that have actually gone to that point yet and have established those impairment levels for marijuana. It's much more subjective.
I know that there are a lot of people that are looking at Colorado and Washington and how they handle these types of situations because they both have not only just medical marijuana, but they've legalized recreational marijuana as well. How are they handling the DUI aspect of it in those states?
You know, in states where there's recreational use as well as medicinal use, I'm not quite sure how they have, what sort of standards they have developed. Now, you take Pennsylvania, which I don't believe has recreational use, but may have medicinal use. In any event, law enforcement there has established a threshold, and I think even though we're really not in a position to talk about each individual state and how they're handling it, the answer really is it's possible. There's been a lot of clinical study and papers written about this issue. It's possible to get close to developing one of these standards and then applying it in the law enforcement setting out on the road, and that probably is the answer. What has to happen is, for impairment purposes anyway, if you're not going to go with just traces and metabolites, law enforcement needs to develop standards that get applied by law enforcement.
We're speaking with John J. Balitis, attorney and director at Fennemore Craig law firm here in Phoenix. It also strikes me, sir, that we are heading towards either more conflicting laws or some form of a constitutional crisis as marijuana use is still illegal on a federal level, and that we have states that may come up with rules, laws, even when it comes to driver's licenses, that are standing in direct opposition to federal law. What does the end game look like for this?
Well, you know, the administration, and we're talking back when Eric Holder was making statements about this, has sort of waffled a little bit on the issue. And initially, when we first passed the referendum here in Arizona, they were sending letters to clinics and saying, you know, we're not necessarily going to go after patients, but we reserve the right to go after dispensaries. Mm-hmm. And now I think they've sort of backed off and really have taken more of a hands-off approach to it. So I don't know if it's so much of a constitutional issue as it's a practical issue in terms of how the federal government will apply its laws when it sees conflicting state laws.
Mr. Balitis, thank you for joining us this morning. Enjoy the rest of your day. John J. Balitis, attorney and director at Fennemore Craig law firm in Phoenix.